So if it's online,
Yeah.
then this will project it onto the.
Northwest Carolina. That's what the city is.
Oh, yeah.
But it doesn't look like it's working.
So,
Nothing to
There's a chicken and egg situation there. And I think that if, and I know the Northwest Section really working in there, as I said, since the
whatever's here,
80s.
and
If
it'll
we
take a
don't
couple seconds to
start
warm up.
transforming.
So it's just projecting from there, is that it?
Right.
And
Cool.
I'll give you a specific example.
Boy, that'd help a lot. In fact, it may help with your.
If you want to go ahead and get to that website, or whatever. Or
Well, you know what I'm thinking.
From your email.
Yeah, actually, from my email had downloaded.
Yeah, just go ahead and plug
Wonderful,
in.
John.
yeah.
I know, yeah, I know that works with them, but
Mail.
right now, we are,
I guess that's
we're
what
planning the station, and which is on the west side of Northwest Second Avenue, between Second and Fourth Streets.
Okay.
And we're actually dedicating, extending Northwest Second Avenue so that we don't have to go from Fourth to Second Street. In part, that was the mitigation for closing the railroad crossing because the platform for all aboard had to close that. So when we're designing that road, we had the discussion with the city. We said, you've got a 50-foot right of way. Tell us what you want to put in it. And they said, we want it to be a complete street. Even though at the south end, from south of the proposed station to Broward is owned by the state of Florida right now, and it's not going to extend. But we're putting in the pieces with the ultimate configuration, because in the long run, that's how we want the community to evolve. So you gotta start somewhere.
So they got their fixed expenses.
So if you say it's not working, if you don't put the right stuff in place today, it's not gonna work in the future. You gotta start somewhere. Somebody's gotta say, I'm gonna make it. I applaud you.
So what does, how long of, most partners are?
Yeah, remember, I make love, not war.
Yeah.
It's a pleasure. Best of luck to all
Good time,
of you.
man.
Good luck. And you can have your single family home. I don't want it. In fact, would you like to buy mine?
I was just gonna ask you if I could touch base once I read
Sure.
the book.
Read the book and give me a call.
And I was gonna give you a friend of mine, so I'll send you an email. I'm gonna order when I get home and I'll read it. Well, probably not next year, just getting married, but whenever I talk. Reading it.
Look forward to hearing from you. Best of luck.
Excellent. Thank you very much.
This was fun.
Absolutely. Never seen Steve, but.
Hi, I'm Steve Janessa.
Hi, Steve.
Very glad to meet you.
Nice to
Debbie.
meet you.
Steve is teaching our motorcycle law course.
Oh, great.
Stuff you could do the.
No.
Would you like to stay for for 6 hours? For 6 Yeah.
Hey,
It's a long day.
it's a long day.
Thanks for kicking it off.
My pleasure, and I just sold a house my husband and I had lived in 20 years ago. We had a rental property in Victoria Park. And as I told you, I hired one of my real estate partners to do the closing.
Good move.
They don't do zoning, I don't do closing.
I hope you told everybody that.
Well, you can quote me on it.
I promise. Tell them that's just what it is. Thanks. Nice to meet you. Take care, Fred. Shall I do that?
It's on.
You let me know.
Yeah, it's about the thing. Yeah.
No, I mean, it's old. You're taking it home. You want me to just plan on taking it home? Have a good day.
I've been like waiting all the
You wanna blow that up?
Yeah, but I can relate it to something.
How visible is it back here?
We can see the shade.
That's the one that I sent you.
Yeah, well, it's at 36.3%. Let's do a little bit bigger if you want to try it.
Yeah, we run out of screens, but I guess you can focus and then move around.
It's just, you just kind of drag it and move it around.
Yeah, but this will give you the ability. Is there a pointer in here, you know?
Yeah, I think we have one of those,
Is there a stick? I brought in actually my paper one, and I thought, well, hell, we're all gonna have to get around a table and do it, and I asked Fred, I didn't know we had this capability.
yeah, I would best, but I guess you can just, when it if you want to do a little more to a certain section, you can do that.
Yeah, and then you can move it around, so that's, I better get a door or a water.
Oh, we put the lights and make it a little more.
By the way,
Shit. That one too. There you go.
Good deal. Good thought. Okay, thanks.
You got it. Alright, thanks.
What's that company again?
Milton Jones Development.
I know the next class will start on 17th.
There you go.
Oh, you're such a sweetheart. Thank you. Thank you, Mrs.
I left my thing in the car.
Thank you,
I didn't marry my dad, so it's not Mrs.
Thank you, Mrs.
Mine in the car. Paper we have to print. Did you print it? It's on the car seat. So mad. You don't have it?
But it's right.
Yes.
It was there.
And I like it.
That's the whole time for
You saw it, it's in my car. The right notebook.
Maybe are we just not have it?
I want to go home.
Whose is this, Robin? Is this yours?
Yeah.
It's on the ground.
Go with a gunka baby.
Yeah.
My gunka.
Yeah, what?
What on earth is Shaq lunch?
Whereas before, it's a different story.
Water in there.
Well, next to the one where parents do that.
So I was talking to someone about what's going to happen.
Professor, did we all pass?
Yeah.
Professor?
Our reason for like whoever developed these are.
Professor?
And they left it until maybe.
Good morning.
Good morning. I was.
What did you call me?
I
I
said,
heard a noise, I
Professor.
couldn't tell what.
I kept saying, Professor, did you pass?
I don't answer that usually, I'm not used to it.
Oh, not exactly.
It's not the one that, when somebody says professor, I'm looking around to see where the hell the professor is. He said, Steve, I answered. Yes, ma'am.
Did we all pass?
Yeah.
I'll take it.
Yo, I'm gonna talk about that. I'm gonna pass them out later. We're not gonna pass them out, we're not gonna go through them, just because it's too damn time consuming.
Let's get it.
I'll talk about that in 2 seconds.
Robert, we did great.
Make the final just like that.
You could even use some of the same questions,
Yeah, okay, same one. Okay.
but give us the answers to the ones we got wrong first.
Listen, a lot of people knew all the answers. I was impressed. Very impressed.
We've been listening.
We've been paying attention. That's right. Woo! Let's do it.
You know how loud that is on that thing?
Woo!
Yeah, feel it.
We getting
Doesn't
our
feel the
exam
fear.
grades back?
Woo!
Are we going to be getting our exam grades?
Ow. Hello.
I was warned that if I hand them out,
It's on the front seat.
but we'll talk about it now.
That's not true.
I'm waiting. What happened?
Why is the OCD working?
I don't know. I always just sign both of them just to be safe.
I'll just use this one.
In January, I'll be messaging you guys just for the fun of it. How's class? Taking us out. Right, Mike? In January, we can message them. How's class? Going for a run, hitting the gym, taking a nap.
Hey, how did the
I don't know. You guys saw it.
You did? I didn't respond to him.
actually, I was booked on.
Got it.
Look, I'm light skinned, man. I'm bruised.
What are you trying to say? Oh my God, you really are. How many times did I hit you this morning?
I'll put this on camera.
How many times did I hit you today? You gotta switch feet. I gotta even it out.
You just sitting up here. Changing my seat.
Second you're leaning over towards you. I'm gonna go, oh no, Robert, not the face.
Education stay a little longer. Still at the end of the day.
Okay, morning.
Good morning, Mr. Ginestra.
Steve, please. Thank you.
AKA
Hi, folks. Another beautiful day. I'm sorry we're in here again on a pretty one. I wish it was like last Sunday and it was raining all day, so we didn't feel like we were missing anything. Midterm. Very impressed. Everybody did great. Out of 16 students, we had 8 A's, including A minuses. We had 4 B's, and we had 4 others. Others still have time to recover, to do better. But the A's and B's are great, and 4 were not so great. But I'm quite sure with a good job on the final, those folks will all do well too. I'm going to pass them out at the end of class. We're not going to go through and discuss all the questions merely because it's just too time consuming. We're under a lot of pressure to get finished with the book. I've got 6 chapters I want to cover today. And that's going to be long and tiring, and hopefully we can yuck it up a bit and make it a little bit of fun. I'm going to try. So that I don't forget and we get off into just handing out the papers and saying bye. The assignment for the next class is to finish the book. Whatever we haven't covered today. Remember the chapter on escrow closings, which was chapter 14 for those of us in the 7th edition. I think is chapter 20. And the few folks who have the 8th edition, we're not doing it. Skip it. Also, so you'll know, there is a chapter chapters 24 and 25 are on land use planning. We're going to hit them lightly. So there are a few sections in each that I want to talk about. But the point is, I know you have another entire class in land use planning. I know that's what Debbie does. It was here a moment ago. I know Tracy's your other instructor that gives you a whole course on that. For those of you who haven't had it yet, you're going to have it in depth in that later course. We're going to touch on some of the high points, but we're not going to get deeply into either of those 2 chapters, other than to the extent that once I read them, which I haven't yet, I think that there's stuff that won't be covered in your other classes. As to that next class, the chapter that is going to be of most importance, and which I'm going to spend the most time on, is mortgages, chapter 21. I think that's huge important. I'm going to send you a commercial mortgage a couple of days before class, and we're going to go through it and discuss it as part of the chapter. Not only a note and a mortgage both, but I think that's the most important thing we have to follow from those chapters that we have assigned for next week. I think we have some real important stuff for today too. And so obviously whatever we don't get through today, I'm hoping to get through chapter 20. So that remaining will be chapters 21 through 26 for the next class. And obviously at the end of the next class, then we'll have a final exam. I anticipate it being similar in format to your midterm, longer, and comprehensive. It's the whole course. It's not just 2 new classes, what's new. It's material that we may have covered already. You may have some of the same questions again. I doubt it. Maybe some similar ones. But they will go all the way back to chapter 1. And the exam will include a little bit of what we cover in class that day, that last final day. For sure, mortgages. There are going to be some questions on mortgages, so I urge you to read that chapter well, and we're going to discuss it at length. And then we're going to pretty well blow through the rest of the chapters to get it done. Even if it's 5 minutes a chapter, we're going to finish that thing. I'm committed to getting through the book before your final exam. But know, if you will, I consider mortgages to be hugely important, and there will be questions on mortgages that we won't address until that day. For today then, we're going to try to get through new chapters 16 through 20, but 15 also that was assigned for the last class. So we've got a lot of stuff to cover, beginning with chapter 15. And our target is to get through 20 if we can. So, having said all that, a lot of which will probably get forgotten in the panic when all of a sudden it's 4:30 and you want your papers back and don't want to hear anything else. We best have at it. We finished last time with chapter 13, and we rushed in order to commence the midterm. I want to just state once again that I consider that Johnson versus Davis case that we talked about last, about fraud in residential real estate and non-disclosure and sellers' obligations to disclose things, to be hugely important. The courthouse is full of those cases right now. And it continues, although it was a 1985 case, to be good law today and to be cited by the courts again and again and expanded and refined. But it's going to affect you. And it's something you will need to worry about when you're dealing with selling a piece of property. That, oh my God, am I tripping over anything here, or the things that I have to be disclosing? So please focus on that. Does anybody have any questions on that chapter before we leave it behind for good? That was chapter 14 on, or 13, I'm sorry, on fraud. Chapter 14 then, in the 7th edition, we skipped. That's escrow closings. When we get to our last chapter of today, chapter 20, which is regular closings, we'll talk a little bit about what escrow closings are and why we're not covering them and why we don't do them in Florida. But other than that, it's insignificant. So I'd like to begin with chapter 15, which was the last chapter that was assigned for our reading for the prior session. It's another one of these things. It continues to amaze me the way the book is organized, the novelty of throwing wholly unrelated subjects together into a chapter and giving them one name. And I guess that's how you do it without having 50 chapters in a book. If you're going to have 25, you got to shuffle some stuff together. This one is called Involuntary Liens, chapter 15. It's got 3 totally unrelated subjects, actually 4 or 5. The idea is, here's how you can end up with liens on your property that you didn't exactly go out and consent to. Talk about what liens are for 2 seconds, and then we'll talk about that concept of voluntary and involuntary, but this chapter is involuntary. All right, a lien. A lien is a claim against a piece of property to secure the payment of a debt or some other monetary obligation, but it's a claim against title for money owed. It's not an estate. The point being, bless you, that the right to possess property. It's not the right to possess property. It's not an easement, which is the right to use property. It's merely the right of someone who is owed money in some fashion or for some reason to have a claim against property, to have that property sold in order to pay the debt. So it's a claim against title, but it's not the right to have title. A lien holder never gets your property. A lien holder has your property sold in order to pay his debt. Now, therefore, there are two types of liens. There's voluntary liens, not the subject of this chapter, but a voluntary lien is where you go out and you give somebody a lien. You intentionally sign up papers to create a lien on your property. That's what happens when you go out and get a mortgage. That's chapter 21 that we're going to talk about early in next class. That's a voluntary lien. But a mortgage creates a lien to secure the payment of a debt, but it's voluntary. These liens in this chapter are involuntary. These are things that just happen, like stuff happens. Normally it's based on something you've done, but you have not intentionally gone out and said, hey, please put a lien on my property. Now, the first type, and this is hugely complicated stuff, and the subject of conceivably a whole course, but this is mechanics liens. Mechanics liens arise out of construction work on property, basically. We'll talk about how that all refines. When I was a very young lawyer and had only practiced a few months, local bar association had a radio show, and being the youngest, lowest man on the totem pole, I was sent on Saturday morning to be the guy to sit there on the panel and talk about mechanics liens, and then answer phone questions. And so I studied up on it, and the DJ type guy said, all right, we'll open up the phones for the phone call. And the first phone call coming in is some guy who said his outboard motor had been worked on, and the mechanic wouldn't give it back to him until he paid the bill. And that's a mechanics lien, right? Yeah, sorta. But that's not what we're here to talk about. We're here to talk about liens on real estate. But the concept was a little there. Somebody worked on something and wanted to be paid for it, and made a claim against the piece of property that he worked on. It was just so far out of left field, I just sat there and stuttered for a while thinking, you know, but it's a good, very basic example of where we're going. A mechanics lien is it's a lien created in favor of someone who renders services or supplies material in connection with improvements to real property, and as we talked about what the lien means then, and therefore creates his right to have a judicial sale of the property to pay his claim. That's a mechanics lien. The guy who gets the lien is a lienor. Lien-or, lienor. And you have mechanics lienors, and we have other kind of lienors, but this is the concept of having a lien. The person who has a lien is a lienor. And in specific cases, we give them other names, but in general, it's a lienor. So, the materials then go through all the different concepts that we're talking about here. I'm not sure this is worthy of drawing a picture, but picture this for a second. You own a piece of property. You hire a contractor to build you a house. He's going to have a lien if you don't pay him. But that's really kind of, that's the super simplistic part of what we're talking about. But that contractor is going to go out and hire a bunch of subcontractors, a plumber, an electrician, and 100 others. And they're going to work on your property and they're going to improve your property. And if they don't get paid by the contractor, then they're going to get a lien on your property. Maybe. If they do all the gazillion things right, maybe. In addition, that general contractor is going to hire somebody to bring in concrete, Old Causeway Lumber to bring in lumber, and all these people are going to come dump supplies on your property, or maybe install them. And if they don't get paid, they're going to get a lien against your property. But you, the owner, are not paying them. You're only going to pay the contractor. So the whole idea of the mechanics lien law is to protect these claimants. It's not to protect you, the owner. It's to protect the guys who are working on the property to make sure that they get paid. That's what it's all about. Yes, Mark?
Who's the lien on, the contractor or the owner?
Whoever files, oh, I'm sorry. Whoever files a lien is a lien.
Files a
owner.
lien.
Whoever files a lien. Yeah. Yes, sir. Yes, listen.
Okay, if the property is owned by an LLC or corporation,
Uh-huh.
and as a contractor, you directly contract with the officer of that company,
Uh-huh.
do you still have to file a notice to owner?
No. And we'll talk about why not in a few minutes when we get to the notice to owner contract. If you're in privity with the owner, if you have a contract with the owner, then the law presumes that the owner knows about you. So that's why you don't file a notice, but we'll get there. Yes, ma'am?
You said that the subcontractors can put liens on a property,
Uh-huh.
that the general contractor, so what happens if you pay the general contractor and the general contractor
So
doesn't
what
pay
if,
them?
I'm sorry, what happens if you pay the general contractor and the general
Yeah,
contractor
and-
doesn't pay them?
Yeah.
We're gonna talk about that at length. And that, I want you to understand, we're gonna get to this at the end, but I want you to understand the huge exposure here that you have as an owner, hiring a contractor, making sure everybody gets paid. In Florida, and this is the punchline, you can pay twice. You can pay twice for the same work. And it's zeal, for lack of a better word, of the legislature to protect people who work on property. The laws are structured such that it's your job as the owner, even though you hired a contractor and counted on him to pick the subs and counted on him to pay the subs, under certain rules, it's your job as the owner to make sure everybody gets paid. And if you don't, you can pay twice. That's why this is scary stuff. There are lawyers who do nothing but this. Some of them represent contractors. Some of them represent owners. And it's an incredibly technical area with dates and rules, and you got to do this exactly right. And you can miss a deadline by a day and be out, or you can be, if you're the owner, protected by a day. Hugely technical. Scary stuff. We're going to talk about the high points, and at the end of the day, I'm going to urge you, if you have any question you get in a situation like this, go find a good lawyer. Or go find somebody who really understands this stuff that you can rely on, because it is hugely technical. Now, with that concept in mind, though, of the owner hired a contractor and signs a contract with a contractor, that contractor is going to go out and sign contracts with all these subs and sign contracts to buy materials, and the owner's not a party to those contracts with the subs. Those are subcontracts. And I just want to tell you all this as the background so that as we go through each of these things, you'll have some frame of reference of what the hell we're talking about here. And I could draw a picture, but you know, this piece of property is going to get worked on, and the owner signed a contract with a contractor, and he's going to contract with all these other people. Okay. Now, claimants, the type of people who can claim are any who can file a lien. Types of people who can file a lien are anybody who has a direct contract with the owner. We'll talk about some of those in a moment, but just so that makes sense, the contractor has a direct contract with the owner. Probably the architect has a direct contract with the owner. Architect maybe got hired by the GC, but more likely the owner hired an architect, had plans drawn up for whatever he wanted, and then he went out and found a GC. Anybody who contracts directly with an owner to do work on his property, and does work on his property, and doesn't get paid, can file a lien. In addition, all these subcontractor types we talked about, all these people who have contracts with your contractor, or supplied material, bless you, to your contractor for your property, they can have a lien too. Okay, now, we got to have an owner to do that. The owner owns a piece of property and he hires a contractor. But the owner might be a lessee. Remember we talked about land leases. Tenant's going to build it. So a leasehold interest is enough of an interest in property to create liens, maybe. And there are all kinds of confusing rules about that, about whether work that a tenant has done on a property can create a lien on the owner's fee title. Huge area of litigation. But conceptually, ownership interest, somebody has to have an ownership interest, and that can be a tenant also. The type of work. It's got to be an improvement. But improvement is not just sticks and bricks. It's a surveyor. That's considered an improvement. Drawing a survey improves the property. Architects, engineers, design services, they don't have to come dig a hole or hammer a nail or do anything to the property. They have to have done some work that creates an improvement to the property. There has to be a contract. Somebody has to have signed a contract to get the work done on the property. The owner we talked about. That may be the tenant, but there has to be, that's called the prime contract, the main contract, the contract to get the work done, from which all these other subcontracts arise. Yes, sir. And it doesn't have to be in writing.
That was going to be my question.
Yeah, absolutely. You hire a guy to do some work on your property verbally, that's a contract. And he hires other people to come do it, that's a subcontract. Can be all verbal.
And if the GC does like a verbal contract with a subcontractor and they come and they improve, he can still file it?
The sub, absolutely.
The sub, okay.
The sub does not need to have a written contract. And by definition, a sub does not have a contract with the owner, right?
Right.
That's what a subcontractor is all about. The GC has a contract with the owner. Or the architect has a contract with the owner. And the architect hires subs out some of the planning work, you know. But there has to be a contract with the owner, a prime contract, and everything else is a subcontract, unless it's a contract with the owner. The owner may decide, I'm going to hire the plumber myself. GC, you do everything except, or hell, I'm the plumber. You know, I'm a plumber, so I'll do my own plumbing. And then I may sub out. The point is, if the owner signs a contract, that's not a subcontract. If it's a contract with somebody the owner has contracted with, and remember, there are subs. And there's, I used to represent a corporation that built shells. They were called a shell contractor. The GC hired a shell contractor to build the shell of the building. And then, so they looked like a GC, but he wasn't, because then the GC had to hire plumbers to do the inside work, or guys to do the frame up inside rather than the shell. I mean, so that it can even look like a contract for the whole building, but it's not. The definition of the contract here is it a contract with the owner? There has to be a contract with the owner at some level. Okay. Yes, sir?
You might go into detail of the hierarchy of the lien holders.
Hierarchy
Like,
of what?
like senior, junior, at what point are they all going to be satisfied as when it comes to payment? I mean, the senior lien holder supersede a subcontractor so much as, you know, payment?
Not necessarily, no. No,
Okay.
the GC's lien does not take priority over anybody else's lien. Liens, believe it or not, take priority on when they got filed.
Okay,
And that's, of course, kind of when you get stiffed,
right.
you know. And so that sometimes the early on guy, and we can get off into remembering that there's probably a construction mortgage. And if the construction mortgage is done correctly, all of them are behind the construction.
Right.
But priority in liens is order of filing.
So you're like 90th day not getting paid, is that when you want to go after them, or 60 days or 30 days?
Yeah, you have the right up till 90 days after the end of your work to file a lien.
Okay.
You can file a lien immediately if you haven't been paid, if you satisfy the other requirements.
Right.
Notice to owner, final affidavit, all that. And we're not going to get that deep into, because candidly, I want us to treat this as if y'all are real estate developers in the owner's capacity, not as contractors. That's a different class. Okay. There has to be consent of the owner. Now what that means is, the owner of the fee title maybe is who signed the contract, but maybe not. In our lessee example, if the owner signs a ground lease requiring basically the tenant to build a building, the tenant is going to be the one who signs the contract, but the owner has certainly consented to the work being done on his property. What this means is, if as a contractor you go out and improve the wrong property, that owner didn't consent, you don't get a lien against that piece of property that you worked on. The owner has to have consented to the work being done, which normally means owner into a contract, but this gets off into legal descriptions and the portions of the property, and it can all get really just scary technical. Okay, has to be a permanent improvement. The type of improvement we're talking about has to result in a permanent improvement to the property. Now, permanent benefit to the land. That means mowing the lawn is not a permanent improvement. But laying sod is. And you can argue, you know, painting, pretty permanent. Pretty clear a painter can get a lien. You know, somebody might come in and say, yeah, but in 5 years it's going to need painting again. Well, in 20 years it's going to need a roof again. But they're considered permanent improvements. I thought that was a good example in the text, that mowing the lawn is not. But I added, but laying the sod is. Landscape work counts. Putting in plants, laying sod, that's permanent. All right. Now, in order for a lien to be created, the lienor has to perfect his lien. And this is where it gets real hairy. I'm going to discuss only two of the steps that a lienor has to do. There are many others, but these are consistent in all the laws anywhere in the country, and they of course apply in Florida too. And the first one, maybe it was Dustin, I'm not sure who mentioned notice to owner. Yeah, notice to owner. All right. Theoretically, as the owner who signed a contract with the general contractor, theoretically the owner doesn't know that there's going to be a plumbing sub. You know, it's probably my plans call for some plumbing, somebody's going to do the plumbing, but he doesn't really know whether the GC is going to do the plumbing himself. The GC is contracted to build the whole house. We'll talk about a house just to keep it simple. And the owner knows a part of his plans include plumbing, but maybe the GC is going to do it. The owner does not know that the GC has signed a subcontract with a plumber. It's not a party to it, hadn't signed it, hadn't seen it, doesn't care what it says, doesn't care what the price is, as long as it gets my plumbing in accordance with my plans, that's all he cares about. So theoretically, the owner does not know that Joe the plumber is doing the plumbing work. For all he knows, it's GC's brother. Doesn't know, doesn't really have to care. So, as a subcontractor, when you begin work on the property, and there are all kinds of date rules on this, or as a supplier, when you supply materials to the property, that person doing the work, supplying the materials, in order to perfect his lien, the first thing he's got to do is file a notice to owner. That's where the sub, or the material man, we call him, material man who supplies materials, sends a notice to the owner that says, I want you to know that I'm working on your property, or that I'm delivering materials to your property. And what it also says, although it doesn't really say this, and it does if you read it, but nobody reads them, it says, it means you better make damn sure I get paid. That's what this is all about. The material man or the sub, am telling you as the owner, this is your notice, I'm working on your property, I want to be paid for it. Now, it says who his contract is with, so he's saying right in there, I know I don't have a contract with you, Mr. Owner, I have a contract with the GC, but I'm telling you, Mr. Owner, I want to be paid. And you better make sure I am.
Does the subcontractor demand this information from the contractor?
I'm sorry?
How does he get the information, of the owner information?
Two things. We're not going to go into this at length, but there's a document called a notice of commencement that is posted out with your building permit. You know the sign, out the box out there with the plans and the permit in it out on the street and the building permit? That lists the owner, that lists the legal description, that lists the owner's address. In addition, supposed to be posted right next to it is a recorded document called a notice of commencement. And that's something an owner signs and records. It says, I'm telling the world I'm the owner, I'm commencing work on my property, here's my name, here's my address, here's my legal description, here's my da-da-da-da. That's all supposed to be there, posted in the box. The way most of them do it is they go hire builder lien services or something to do it. There are companies that do this. And they're pretty good at following the rules because that's all they do. So, but the problem is the sub, you got 45 days to do that after you started work on the property. You didn't do it, you're not getting a lien. Things are looking bad after 50 days, tough. You didn't file a notice to owner within 45 days. You don't need to know that 45-day rule. It's an example of there are, and the things that have to be done just right in this notice to owner are just ad nauseum. The point is, it's highly technical. You can screw it up, but we're not talking about the problems that the lienor has. We're talking about you as an owner.
Right.
Yes, Dustin?
I guess two questions. One is, does the notice of commencement have to be filed
Yes.
in order to have a lien right? Like
No.
if you just do the
No,
notice-
no, no,
Okay.
no.
And then the other question is
Theoretically, the
Right.
Florida statutes require an owner to file a notice of commencement.
well, I mean,
But
if
they
you
don't
did a
do
job,
it.
let's
But
say
they don't do it.
that you didn't pull a permit on,
And they're supposed to post it on the job, but they
Right.
don't do it.
but like if
But
you
that
did a
doesn't
job-
affect you as a lienor getting to have a claim against his property. It just makes it harder to figure out where to get the information in order to prepare your lien. Did you have a two? Number two?
Yeah, the second one is, I guess, like, what's the definition of the start date? Because
Of a
that's-
who?
Of the start date. So, you know, you have
That
45
gets
days.
litigated all the time. You know, was it
Because
the
I
day
mean-
you first dropped some materials on the property? Was it the day you showed up to work? That's,
But I mean, you can file your lien and then that gets litigated on what day it was actually started.
well, that's later. We'll come to that. That's number two. The second thing that the lienor has to do to perfect his lien, the second thing that we're going to talk about among a dozen things, is he has to file a recorded claim of lien. This is a document that the plumber signs and records that says, it's within 90 days after I finish my work, I haven't been paid, here's how much I'm due, Mr. Owner, I'm filing a lien against your property. Those are the two biggies. There are many others, but those are the two biggies. You have to have, and the point being, we're gonna relate this back to you as the owner now. You don't even know about the sub unless he's filed a notice to owner. And if he files a claim of lien, you find out about it because you get a copy in the mail and it's recorded in the public records. And you may or may not be able to defend against him because he didn't file a notice to owner, maybe he didn't get it. These are all the poking holes in the lien concepts that you can do based on all the deadlines and rules and pitfalls. But the point is, the lienor has to do both of those things, and if you as an owner get wind of either one, you got some serious responsibilities. Now we're going to get into those for a second, but I want to point you at the text, and remarkably, the text in a section called termination, which is their last section on mechanics liens, talks about, well, how does a mechanic lien get terminated? Well, of course, like any lien, or any mortgage or anything, if it gets paid and satisfied, well, that sure as hell takes care of it. But what's important here is reading that section called the Pennsylvania Rule. I didn't know it was called the Pennsylvania Rule, but that is the rule in Florida. And that's what we started this talk about. It says under the Pennsylvania Rule, an owner can pay twice. Yeah, Florida too. And it talks about under a New York rule, the owner can't pay twice. Well, we don't have that. We do not have that protection in our law for an owner. In New York, they're looking out more for the owner and saying, yeah, you should, it's not fair, you should only have to pay once. But what we're thinking through, what we're talking about here, remember that the owner is paying the contractor, and the contractor may be stiffing the subs, and they're not getting paid. So in Florida, we're more worried about the subs getting paid. In New York, they were more worried about the owner having to pay too much. Now, here's what this means in the real world to you as an owner. You signed a contract with your contractor. It probably requires payment in stages. 20, 40, 60, 80% completion based certified by an architect, whatever, but stages. Or maybe when the slab's down, maybe when the walls are up, maybe when the tie beam, maybe when the roof, maybe those are stages. But at each stage, you're gonna put out some more money to the contractor. And when that time comes to pay a contractor, you're gonna wanna know, has anybody sent me a notice to owner? Because I'm worried that I'm gonna give my money to the contractor and he ain't gonna pay that guy who sent me a notice to owner. And I wanna check the public records and see, by God, has anybody filed a lien against me? Maybe I didn't get the notice to owner, but maybe somebody filed a claim of lien. So every time you're making a payment to the contractor, and of course, on your final payment to the contractor, that's almost a no-brainer. But at each of these stages where you're making payments to the contractor, you gotta check and make sure, count up all your notices to owner, and then here's what you do in the real world. You require that the contractor bring you a release from each guy who has filed a notice to owner saying, I release my claim against your property to the extent of $8, so that you know when you pay that stage money to the contractor, that sub has already said, I release my lien based on that payment. Now, if the contractor is not getting along with the sub, they may both come to you together. And the sub may even say, I don't trust this contractor anymore. If you want my release, you're writing a check directly to me, the sub. And the contractor is going to say, no, don't pay me. And then you're going to say, contractor, fine, then I'm not paying you. And you're going to have a war. But if you don't pay that, if you don't get a release from that sub or take care of that sub or that materialman who delivered the lumber or the concrete, then that guy is later going to have the right to file a lien against your property if he didn't get paid. That's what it all boils down to. So that if you just sit back blindly and say, yeah, my contract calls for me to pay 20, 40, 60, 80%, 100% final payment to the contractor, and just keep writing those checks. And all these notices to owner are coming in, and he's stiffing everybody, and these guys are filing liens against your property, but you don't even know it. You're going to owe them too. Now, if they do file these liens, by law, you have the right to offset that amount against what you still owe the contractor. But if you've already paid him and he's gone, those liens are still on your property. That's what it all boils down to. And in Florida, you can pay twice. You can pay the contractor for that first 20% that included the foundation, and he didn't pay the concrete guy, and that concrete guy's going to file a lien. Now, hopefully, you catch up with all that before the final payment to the contractor, and you get to work it all out. But sometimes you get to the end, and you got 20% left owed the contractor, but you got 60% worth of liens filed against your property already. That's where you end up in a courthouse. And that's where jobs, sometimes jobs break down in the middle and don't get finished because of this. And of course, then we can get off into all the stuff about, you know, a GC with a good reputation. I mean, in the real world, you've now heard the technicals. But in the real world, a strong GC says to his subs, don't you dare file a notice to owner. Don't you go upsetting the owner and worrying the owner that I'm not paying you. So the sub doesn't know what the hell to do. So he maybe doesn't file a notice to owner. Because the GC says, I'll never hire you on another job again if you file a notice to owner, or if you file a claim of lien. So he doesn't. And then he got stiffed. There's a lot going on there that creates the dynamics. It's not as simple for the sub to decide, okay, these are the rules, do this. You may never work for that contractor again. Because the contractor isn't real happy when the owner says, I'm not paying you, Mr. Contractor, because I have 7 notices to owner here, get them all in here. And adding a step further to this, very often the owner has a construction loan. And it's not the owner paying them at all. It's the construction lender. And by God, he's doing this. The construction lender has a title service searching not only for recorded liens, but also counting up all the notices to owner. And before that construction lender makes that stage of completion payment to the contractor, they're doing all the things that I just told you to do. And they don't give a damn whether the contractor likes it or not, because they want the job finished. Now, know, if you will, the construction lender has a lien ahead of all these guys anyway. So the construction lender is going to come out okay, except maybe the job isn't going to get finished. That's why it's important to the construction lender that everybody gets paid, everybody's happy, everybody's finishing their work, because the construction lender wants it finished. Now, and he may have a bond, and there can be all kinds of other things, and there are ways to, you know, to post bonds so that liens are filed against the bond rather than against the property. I mean, seriously, this is a, when we talked about condominium being a huge area of statutes and law, so is this. Highly technical, very sophisticated, and sometimes big money. I mean, you know, somebody building this building, you know, has a $10 million construction loan with stages and subs doing work in each of those stages for maybe worth $250,000. I mean, this is big stuff and big numbers and big wars and big pressures between contractors and subs and materialmen. GC says, I won't buy my lumber from you if you're going to file a notice to owner. Because the owner gets this and goes, whoa, notice to owner, this looks like a lien. This looks like my contractor's a bad guy and he stiffed Causeway Lumber Company. You know, so they don't like you doing it. But if Causeway doesn't follow the rules, maybe they don't get paid. So it's scary stuff. My lesson, please, is if you get in a mess, go see a lawyer, a specialist lawyer, or somebody who really understands this stuff. Because as owner, you can get in a hell of a mess. And you can end up, oh, and you signed $1 million contract to build a building, you can end up paying $1.7 million. Because you paid your contractor the $1 million, but he stiffed all these other guys. And that's just basically tough. Because you, as an owner, didn't follow your requirements under the statute, which were to see that everybody who sent you a notice to owner gets paid. And everybody who filed a lien against your property gets paid. And to worry particularly about those before your final payment to the contractor. That's kind of the catch-all at the back end. The job is done now. Let's see if everybody gets paid. Now at that point, I want to see a release from everybody. And even if I'm being real careful, even if a plumber didn't file a notice to owner, and I saw Joe's plumber truck out there, I want a release from Joe's plumber. I don't want to count on the fact that maybe he did file it and I lost it. Or maybe the dog ate it. You know, you can't just decide, wow, I'll use all these little technical things and I'll bust their chops and too bad they don't have a lien. Maybe they do. So basically, as the owner, you got to pay attention.
So as the owner, shouldn't you just do that up front? Have all of this, have all these requirements in your
Well, and
contract?
there are services you can hire to do all this for you too, as the owner. And big construction people do it. And these are there's a word for it, construction managers do that. And they sit there and deal with the GC and all the subs. And then the owner has somebody responsible to him if this all gets screwed up. Just as a construction lender has a whole department to do all this kind of stuff. But then they hire somebody else out to do the title work. Because as I said, you got to check the title every time and see what are any liens out there. The fact that you didn't get a notice to owner, maybe you lost it. But the guy thinks he sent you one and he filed a lien against your property anyway, so each time before you do a draw, you want to do a title search and see, are there any liens out there from somebody who maybe did or didn't send a notice. In either event, you got to worry about it. Yes, ma'am.
Once the notice to owner is filed, does the owner have a certain window to respond before the contractor can file the lien? Like, he files a notice to owner, does it give the owner 60 days to respond, then he files the lien, or he can just go ahead and file the lien immediately?
The sub can file a lien the same day as a notice to owner if he wants to. It's kind of premature at that point because you're just working on the job. Normally, a sub does not file a claim of lien until the end of his services. And that's why the statute gives him 90 days after the day of his last work. And that gets litigated all the time. What was the end of his work? Well, he came back to fix a few things. He didn't do the baseboard right, so he came back 2 weeks later and put a few nails in the baseboard. Does that count? Does that extend in 2 weeks or not? You know, again, these are the type things that lawyers fight about and subs and GCs fight about in front of a judge to see is the guy's lien any good or not. But they're not the types of things that you want to use when a guy files a lien and you say, nah, it's been 4 months, I'm ignoring you. That would be really dumb. Because maybe he did come back and do some work and you didn't even know about it. And it wasn't more than 90 days. Maybe it was only 60 days since the last time he was on the job doing some work. So all these little rules for shooting down the liens are nice, but you don't want to rely on them. You just want to see everybody gets paid. As the owner, that's all you care about. Let's get them all paid, and then it's not my problem anymore. And the GC may be mad as hell that you're out there writing checks to all these subs. Well, that's tough. You should have made them happy.
Is there a website in Florida you can look up GCs to see if they've had these issues with properties where their subs are?
I don't know. I don't know.
Just go to the, you just look at the state license, if they're compliant.
You can check licensing without question. Whether it says how many subs end up, how many GCs end up with liens against them, or how many default on jobs and stuff like that, I don't know. That sounds to me more like a Better Business Bureau type thing or something. I just don't know.
Or business opportunity.
Yes, sir.
What we do, I'm a general contractor, when we have a hard time getting payment from the owner, and we're contracted directly with the owner, we'll just send them a notice to owner after, even if it's past the deadlines or whatever.
Well, as a GC, you are not required to ever send a notice to owner.
But you always get the owner calling you, okay, I'll pay this, can you take the lien off? It's like, it's not a lien. Everyone thinks it's a lien when they get the state, the notice to owner, because it says right on the top.
Oh, it says right on the top, this is not a lien, right?
Well, yeah, well, it says this is a preserved for lien rights. I mean, they make it look like, it scares the owners.
Yeah, that's exactly, that was my point. That's why GCs say, don't you dare file one.
It's an inexpensive way to motivate an owner to pay the GC.
Yeah, but understand that the reason and the concept of the notice to owner under the law is to tell the owner who else is working on his property.
Right.
He's presumed to know that if he signed the contract, that guy's going to work on the property. Okay. That's it for that section. It's heavy stuff, complicated stuff. The second type of involuntary lien. These are, things that happen to you as an owner of property. And the second type of involuntary lien is a judgment lien. Now, this is when somebody gets a judgment, a court judgment, against the owner of a property. And that judgment acting as a lien against the piece of property. Now, the definition in the book is horrible. It says it's a lien that attaches to real property of a defendant when a plaintiff wins a judgment in the jurisdiction where the property is located. Nah. You can sue somebody anywhere. You get a judgment against somebody that owns property, and you properly record it where the property is. That creates the lien. What I'm saying is, somebody, the owner of this building, somebody gets a judgment against the owner of this building. It doesn't have to be a Broward County, Florida judgment. You can get it in Palm Beach. You can get it in New York. You get a judgment, recorded court judgment against the owner of a piece of property, and you record it where that property is, following a bunch of super technical rules again. That creates a lien against that piece of property. Do not have to have sued them in the county where the property is located. Yes, sir.
So just to confirm that, if you get sued by somebody, they have to put your property in the documents?
No, not at all. Absolutely not.
So what do you mean if it's properly recorded?
Just simply recording it. And even recording it, you don't have to mention the piece of property.
So if the suit is properly recorded, is that what you mean?
If the final judgment of a lawsuit, if the defendant named in the final judgment, where the court says the defendant owes $50 million to the plaintiff, okay? And if that final judgment is recorded in a county where that defendant owns real estate, that judgment is a lien against all real estate owned by that defendant in that county. And it does not mention the piece of real estate. Just a judgment. Okay? Any old judgment. That's why we'll talk about later, but why when you're dealing, you're going to a seller and you're going to buy a piece of property from him. That's why we do what we call a name search on that judgment, on that owner. We're no longer then searching a certain piece of property. We're searching Joe Blow, the seller, to see if there are recorded judgments against Joe Blow. Because any judgment properly recorded in Broward County, from wherever that judgment came, whether from Las Vegas or from Tallahassee or from Fort Lauderdale, if it's recorded here and the judgment debtor, the defendant, the person that owes a debt, owns property here in Broward County, that judgment is a lien against the property.
So if the judgment was recorded in Los Angeles but never got recorded in Broward?
Doesn't affect property in Broward. Might affect some property in Los Angeles.
Okay.
But doesn't, it can, you only, so that's why I want to make that big distinction about the definition. Sounds like you had to have sued him here. No. A person who owns property here can have liens against his property as a result of judgments rendered against him anywhere, but recorded here. That's what this is all about.
How does that work if you have a judgment somewhere else?
Yeah, that was my next question.
Well, you have to get a certified copy of it. You have to get it domesticated here. You have to file a proceeding here to have a local judge say that this is a valid judgment, but that's a no-brainer. And then you record a certified copy of it here, and that by itself creates a lien against all property. But the point is, it doesn't name the piece of property. It just names the owner. This is an involuntary lien. I'm the owner. Involuntarily, somebody sued me. That wasn't very voluntary. And they got a judgment against me. That was even less voluntary. And damn, they recorded it here.
Does
lien on my property.
Does that recording have a time frame which it must be done?
Yeah.
After the judgment?
No.
Okay.
But there's some other time frames we're going to talk about in a minute. But right now, I'm just trying to get through the definition, and then we're going to talk about this some more. Yes, ma'am.
Homesteaded properties cannot have judgment liens.
I'm sorry, I can't hear.
Homesteaded properties, if you have a homestead property, no one can file a judgment lien.
You're right. Homestead is exempt. Homestead is exempt.
From a judgment.
That's one of the three attributes of homestead that we talked about was one of the questions on your midterm. What are the 3 types of homestead we talked about? One of them was the exemption from creditors, from judgment creditors. That's exactly what we talked about. If it's homestead, though, it's not a lien. All your other real estate. Okay, good point, very good point. Actually, that's at the top of the next page, but good point. You're exactly right. Okay, now, the person who obtained the judgment is usually the plaintiff. That's no big deal. Is the judgment creditor. We talked about lienor, somebody who has a lien. Well, the person in whose favor a judgment is rendered is called a judgment creditor. And if he records it and gets a lien against your property, then he's a lienor, of course, but he's still a judgment creditor. Now, 2 types of property in Florida would be exempt. They got a judgment against just me, okay? Somebody sued me for $1 million in Texas and got a judgment against me for defaulting on an oil lease or something, or a car wreck, or whatever, assault and battery, whatever the hell. Got a judgment against me somewhere else. Records it here in Broward County. My homestead is exempt, and any property that I owned as tenancy by the entirety with my wife is exempt because the judgment was only against me. Now, of course, if it was against both of us, then it would attach. Those are 2 big exemptions in Florida, and that's why we talked about before why homestead is such a big deal and why tenancy by the entirety is such a big deal, because it is exempt from judgment liens against one or the other of the husband or wife. If it were judgment against both, then of course it would be a lien. But a judgment against one or the other, but not both, is not a lien against property titled that way. But that judgment we talked about would be a lien against every other piece of property that I owned in Broward County if it's recorded in Broward. And if it's recorded in Dade, it would be a lien against all of my property in Dade. And if it's recorded in North Carolina, it would be a lien against all property in the county where it was recorded in North Carolina. That's a judgment. So judgments create a lien. Now remember, I just want to say this one more preliminary thing. When you sue somebody and you get a judgment against them, and at the end of a 3-year trial and heartburn out the wazoo, you know, you guys hate each other. And finally at the end of the trial, the judge says, okay, plaintiff, you owe defendant $1 million. Judge orders, defendant, pay $1 million to this guy. As the text says, and it's a good example, the defendant doesn't just whip out his checkbook and say, yes sir, here's a check for $1 million. Sorry. He's mad. He's going to do every single damn thing he can to make sure that you don't collect on your judgment. He's going to appeal, number one. He's going to try to start moving assets around to try to affect this happening, because it may be moving assets around in other counties, or trying to make damn sure that the plaintiff doesn't find out where he does own property. Because that plaintiff, that judgment creditor, is going to go around and record that judgment and try to create liens on my property wherever I have property. But I'm sure not going to say, by the way, don't forget North Carolina, I own some property up there. You know, so it's up to the judgment creditor to try to find assets and then file a copy of his judgment and create a lien. But remember, whatever property he filed it, probably got mortgages on it. He's behind all those mortgages. If I'm in trouble on other things, probably behind a bunch of other claims too. So it still doesn't mean you get paid. Understand that getting a judgment against somebody, one time out of 100 you get paid. They do every damn thing they can not to pay you. And there are collection law firms who do nothing but go around looking for assets and filing these judgments and trying to create liens and then trying to execute on them, which means trying to have the court sell the property in order to, remember that's what we talked about. A lien is the idea of let's get the court to sell the property to pay me. Just the dodges and the attempts to get out of it and the ways to get around these things are endless. But in order to create this type of lien, you have to record your judgment. In Florida, you have to record a certified copy of the judgment. I can't tell you how many we shoot down because he didn't record a certified copy. A certified copy, you go to the courthouse and you buy a certified copy. And right at the bottom, the clerk signs it and says, this is a certified copy. I, the clerk, certify. Put a seal on there, sign it, pay me an extra $1. This is a certified copy. Because here's what happens in Broward. If you get a judgment against somebody in Broward County, all judgments are automatically recorded. Every judgment rendered in Broward County is automatically recorded. However, what's recorded is the original judgment, signed by the judge. That's not a lien. People get back in the mail, here's a copy of my judgment. Looks like it was recorded. Isn't this cool? No, you don't have a lien. Our statutes require a certified copy of a judgment. You have to go down and separately get a certified copy of a judgment and record it, or it's not a lien. It's a judgment, good, valid judgment, just not a lien against real estate. So, got to record it. And secondly, it's got to name the same party that owns the real estate in order for it to be a lien. Obviously, we're saying it's a judgment lien against the owner of property, so it's got to name that owner pretty much exactly how he holds title. And the effect of all this, as we talked about, is that ultimately, hopefully, you can get the judge to order the sheriff to seize the property and have an auction and sell it and pay your judgment. That's where we're going with all this stuff, is trying to get a way for the court to sell somebody's property to get you paid off. In our mechanics lien situation, yes. In our judgment lien situation, yes, same deal. But it does not mean that you get the property. You don't file a lien, a judgment lien, and say, okay, I got your house. Or not your house, better one, I got your office building. No. It does not, remember, it does not result in ownership. It only results in the ability to have a court sell the property to create a sum of money to try to pay off whatever you're owed. Now, oh, and I'm sorry, you asked me, we talked about term for a minute. And then, of course, now the material goes into termination. How do you terminate one? They always go into stuff like this. You satisfy it. If it's paid, you file a satisfaction. Like you satisfy a mortgage, you satisfy a lien, you satisfy a judgment, you satisfy a claim, anything. But that's not the real importance here. How long does the lien last? You don't have to record it in any certain period of time. You can record a 10-year-old judgment. But it wasn't a lien for those first 10 years, right? Till you recorded it. Okay. After you record it in judgment in Florida, that judgment is a lien against real estate for 10 years. And at the end of the 10 years, if you still haven't been paid, you can record it again for another 10 years. Then you're done. But it might be 30 years total. Might be a 10-year-old judgment. And the reason it might be a 10-year-old judgment is because only 10 years later did you discover the guy had any property in Broward County. So you go record it. Now, and then it's a lien for 10 years. And at the end of 10 years, it takes an action of the judgment creditor to just file a little notice of re-recording, and you record it again, it's a lien for another 10 years. And probably in that 20 years, the guy has wanted to sell the property or get a loan, and hopefully you screwed up his closing. That's best case. Best case. Worst case is he files bankruptcy and wipes out your lien anyway. Or he didn't pay his first mortgage and they foreclosed and they wiped out your lien. But what you really, because this concept of, remember when we talked about partitioning and co-ownership, courthouse sales don't exactly yield top dollar here. You really don't want, but you can, and you can do it for leverage, have the sheriff seize the property and sell it. But it's not going to bring very big bucks. Now, if you only have a $100 judgment and you're really pissed and you want to go through all this, it's probably going to get you your $100. But it's not going to get you market value. So what you'd rather do is hope that he's going to have a sale, sell his property, and see something, when it's time for him to sell. We're going to get to some of these steps before, but I know you guys know a lot of this stuff. When it's time for the guy to sell, somebody's going to search the title, somebody's going to find this thing, and the buyer's going to say, I'm not buying your property until you pay off that judgment. That's your home run. That's what you're waiting for. Or he's got to go into a loan, get a loan. Now, probably when he applies for a loan, he ain't going to get it anyway because probably in his credit report's going to be your judgment. But let's say he gets a loan. Lender searches the title. Lender wants a first lien. Well, you already got a lien. You're the first lien. Pay him off. You get paid off. And in those cases, maybe you'll get everything. Maybe you'll get the whole amount. Maybe not. Maybe you got $1 million judgment and the property's only selling for $500,000. So you go in there and negotiate. You know, I'll give you a release for $400,000 of your $500,000. Maybe you'll take it, maybe you won't. You can kill the whole deal. You can make it not happen. Because you won't give a release, but you ain't gonna get money either. So you may have to, you know, so the point is that that's the numbers, that's the, you know. But the important thing is you have created a lien on his title that in best case is going to screw up his next transaction. Best case is you hope there is a transaction coming. And that maybe somebody will call you up and say, hey, you got a lien, we would like to pay you off. And you say, I'll be there with bells on and I'll be glad to sign a satisfaction. You know, so that's the deal. Yes, sir?
What happens in a condominium if, you know, a contractor's working on at your condo, and like the
Condo unit or
not your unit,
common
but
area?
the common area.
Okay.
Like they're painting the outside of the building, and they don't get paid, and they put a lien on the association. I mean, do they have to file notice to owner to every single unit owner, or?
I don't know. Honestly, don't know. That's a huge area of litigation, is the ability to create liens in condominium situations when your contract is with the association.
With the association.
But the association does not own that land. You remember we talked about,
Right.
A lot of people think it does. No, no, no. The owners in common, as tenants in common, own all those common areas. So they didn't hire you. But the association kind of hired you as their agent. So it gets off into, do you have a contract with the owner, don't you? Did you have to file a notice to owner, to all these unit owners? Because you're really working on their property. And nobody does. Nobody sends a notice to owner to 100 unit owners, you know, who wouldn't know what the hell it was if they got it, you know. So it's tricky. And it's one more heavily litigated area. It can be very tough in a condo association situation.
If they put a lien, if they do file a lien on the association, it does stop the.
The question is whether that creates a lien on the units or not. And sometimes some aggressive, if you're doing a title transaction on one of those units, some people worry about it and say, association, I want you to work this out and get this lien off. Some lawyers know damn well that they don't get a lien against the unit and will close it anyway. And it'll muddy the waters a little bit, it'll cloud the title, and it'll maybe screw up a few closings, and it may help you get paid, maybe. But as to bottom line, when you litigate what you're going to have a claim against, theoretically you may have the right to have the court sell the parking lot. But it's still the association's parking lot, you know, so who's going to buy it? You know, so the concept of the property that you actually worked on and might have a lien on isn't going to do you a hell of a lot of good. Nobody's going to buy it.
Just a quick thing.
Yes, sir.
Going back to signing a satisfaction of a lien, if it's taken a person, say, 4 years to pay off a lien, can you demand interest on that?
Can you demand what?
Interest payments on that lien before you sign the satisfaction?
Well, that's a what type of lien are we talking about?
Just say there's
Well,
a
I mean, are you talking about
transaction.
a judgment lien or a mechanics lien?
Either way.
Because the answer is very different.
Okay.
Under the mechanics lien law, if the general contract provided for interest on unpaid payments, then yes, the sub can get interest on his payments.
Okay.
Under the judgment lien law, every state has a provision that provides the rate at which interest accrues on judgments. So if you got a Nevada judgment and recorded it in Florida, you're entitled to interest when you're paid at whatever Nevada's statutory rate says.
Okay.
Florida has a statutory rate on judgments too. It changes from time to time, I don't know what it is. But anytime a court renders a judgment, if it's not paid immediately, it accrues interest at a statutory rate
Okay.
until it's paid, and the lien secures that too.
Okay.
Okay. Any others on that? We're going to shift gears a little bit for a minute now. Okay, now, there are two concepts here that are not liens that the materials talk about now, but I want to talk about them because they relate to them. And then we're going to go back to a couple more kinds of liens. But these are important, and you need to know what they are. But they are not liens on real estate all by themselves. The first is called a notice of lis pendens. L-I-S-P-E-N-D-E-N-S, lis pendens, notice of lis pendens. And what that is a recorded notice to tell the world that litigation is going on that may affect the title to a piece of property. Not a lien, but it sure clouds the title. Here's the concept. You and I have a sales contract. I'm the buyer. We get in a fight. We're having litigation going on relating to your piece of property. I file a notice of lis pendens, which is a notice in the public record that says, world, I want you to know I'm litigating the title to a certain piece of property. Not a lien yet, may never be a lien, but it's notice to the world that litigation is going on that could affect the title to this property. And what that means is, anybody who buys that property or takes a mortgage on that property after the notice of lis pendens is recorded takes subject to the outcome of that lawsuit that may not occur till much later. So basically, while I'm litigating with you over your house under our sales contract, you're going to have a hell of a time selling it to anybody else. Because they're going to do a title search, and they're going to see a notice of lis pendens that says that I'm litigating over the title of this property. And basically, you're not going to be able to sell it to anybody until our lawsuit is done. So it's a claim in advance of a final judgment, telling the world that there's going to be a final judgment in a lawsuit someday, and it's going to affect this piece of property. And if you get involved with this piece of property now, you're subject to what happens in that lawsuit. In mortgage foreclosures, they're filed immediately. When a lender's going to foreclose a mortgage, a lender already has a recorded mortgage. The lender files a notice of lis pendens, first document filed. That tells the world this mortgage is being foreclosed. You better not buy this property, or you better not put another mortgage on the property till you see what happens in this lawsuit. Because as lender, I may be having this property sold. And it won't be to you. It'll be to whoever the buyer is in that foreclosure suit. So it's a recorded claim against property that a lawsuit is pending. Lis pendens means sort of litigation pending. Lawsuit pending. Okay, but it's not a lien. Yes, sir.
Can you file both at the same time?
Do what?
Can you file both at the same time?
Both what?
The list pending and the judgment lien.
And the judgment, you don't have a judgment yet. You just filed a lawsuit.
Oh.
You filed this at the beginning of your lawsuit. The beginning of your lawsuit, when you file a complaint, you file this notice of lis pendens that says, I'm having litigation here regarding this piece of property. The judgment may not come for 3 years down the road. Now, this doesn't mean that I'm suing you for an automobile accident and I get to file a notice of lis pendens because someday I may get a judgment against your piece of property. Because my lawsuit didn't have anything to do with the piece of property. I'm talking about here a lawsuit that could affect the title to a piece of property. The other thing that you're sort of talking about, we're going to talk about next. And that's really tough. And that's the other second unrelated concept here I want to talk about, which is called prejudgment attachment. Yes, sir.
So, but that's kind of where, like when you do a short sale, you're kind of coming in at the point when the lender is saying there's a lawsuit, but you're going in as a buyer and appeasing whatever the lender wants you to pay for it.
Well, a short sale is a sale where the lender is going to take less than is due. That's all it is.
Is list
There
pending
may or
inside
may
that?
not, there may or may not have been a foreclosure filed and a lis pendens filed.
Just that it's some, okay.
Because it may not even be in foreclosure yet.
Could be current, but not,
Well, yeah, probably in default, but maybe not in litigation yet.
okay.
You only file a notice of lis pendens in connection with litigation. And you file it simultaneously with your complaint, which is the beginning of your litigation. You do it there in a mortgage foreclosure, not because it's a money claim against the owner, but because the lender already has a lien against that piece of property.
Right.
And is saying, there's a lawsuit going on now that affects this very piece of property.
Okay.
Okay. Now,
Wait, what happens if you don't file the list?
I'm sorry?
pendant? What happens if you don't file the list pendant?
what happens if you don't file the lis
And
pendens?
somebody comes along
Then
to buy it?
people don't know that you have a lawsuit going on. And conceivably, in our case, you sold me a piece of property. You and I had a contract and you're the seller.
Mhm.
And I'm suing you, fighting over that contract. You go out and sell to somebody else. That guy's deed may be good. And I may be out of luck in terms of trying to claim your property.
So you
Because I
have
didn't
to-
file a notice of lis pendens.
Okay.
But if I did file a lis pendens and you sold to somebody else, he takes subject to the outcome of our lawsuit, which means I may be able to enforce you to sell it to me. Then he's screwed. Okay? But conversely, if we didn't file notice of lis pendens, his sale may be good because he had no way of knowing that we had a lawsuit going. We talk about, for these judgment reasons, we're going to search the records to see what judgments are there against you that own the piece of property. There's no judgment yet. There's a brand new lawsuit. This is a brand new lawsuit just filed that may affect the title to a piece of property. Now, I want to take this one step further, and this is tough and this is remote, but I think this relates to the question Johnny was asking. Let's say I sue you for an auto accident in Broward County, and I happen to know that you own a non-homestead piece of property here in Broward County. And rather than waiting to get a judgment against you 3 years down the road when you may have sold it, I want to create a claim against your piece of property right now, just in case I win. That's called prejudgment attachment. That's this other concept. This is really tough. because my lawsuit has nothing to do with your piece of property. In our notice of lis pendens, I'm entitled to file a lis pendens because my lawsuit is about your piece of property. I'm talking about that property. I'm suing you for that piece of property. The outcome of my lawsuit will affect title to your piece of property. Okay. In our case, I'm suing you because of an auto accident that has nothing to do with your piece of property across town. But I'm hoping you'll still have it when I get a judgment against you 3 years later. And I'd like to see if somehow I could tie up your piece of property now, hoping I win. That's not real fair to you, right? You may win, and your property's been tied up. In order for me to get a lien now against that piece of property for an auto accident lawsuit that I may not even win, the court's going to require me to post a bond, a very expensive bond, that protects you on that piece of property. So if that was $1 million piece of property that I'm trying to create a lien on now, even though I don't have a judgment against you yet, the court's going to require me to post $1 million bond.